I'm going to talk a little bit about the criminal appeals process in North Carolina. There are three different kinds of things that people sometimes call an appeal. The first is an appeal from district court to superior court. The second is an appeal from the trial division to the appellate division. And the third is a motion for appropriate relief. The court system in North Carolina is divided into two halves. You have the trial division and you have the appellate division. The trial division is made up of district court and superior court. The appellate division is made up of the Court of Appeals and the North Carolina Supreme Court. The district court has a jurisdiction over infractions and less serious criminal offenses, misdemeanors essentially. If you're convicted of a criminal offense in district court, you have an automatic right of appeal for trial de novo in superior court. Trial de novo just means a new trial. Automatic right means that you don't have to have a specific issue or reason that you want to appeal. If you file a proper notice of appeal, you automatically get a new trial in superior court. This automatic right of appeal does not apply to infractions, essentially traffic tickets and some things like that. The second kind of appeal is the direct appeal from superior court to the appellate division. This is what lawyers mean usually when they say an appeal. Direct appeal is started just like an appeal from superior court to, an appeal from district court to superior court by filing notice of appeal in the trial court. There are some fairly specific requirements for notice of appeal and short deadlines, 10 days. So if you think might be something wrong with your trial, it's important that you contact an appellate attorney as soon as possible. Direct appeal to the Court of Appeals is almost sort of like a not-so-instant replay. The judge is like a ref. The coach has to throw the flag to protest the play. The game tape is sort of like the record of your trial, except instead of a videotape, it's the transcript and the court documents. If the camera angle didn't pick it up, you might not get a ruling when it goes up to the booth. Translated into legal terms, issues must be preserved. That means that the trial attorney has to bring it to the trial court's attention, just like throwing the flag. Usually a trial attorney does that by objecting at trial or maybe making a motion before trial. Issues on appeal to the Court of Appeals also can only be based on things in the record, the game tape, so to speak. That means if it's not in the transcript or the court documents, you probably can't bring it up on appeal. Appeals from a guilty plea are even more limited, at least direct appeals. Essentially, a direct appeal from a guilty plea is limited to a challenge of the sentence, and the challenge has to be based on improper calculation rather than it was too harsh. If you think there's some other problem with a plea, you might have a remedy through a motion for appropriate relief. One of the most important bases for a motion for appropriate relief is an argument that the conviction was unconstitutional. Not the statute necessarily or even the way it was applied, but something about the process of the conviction, either the trial or the guilty plea, violated the Constitution. Another common type is an argument that a guilty plea was not entered knowingly, willingly, and voluntarily. The last kind of motion for appropriate relief that I'm going to talk about is a motion based on newly discovered evidence. Not every kind of newly discovered evidence can be the basis for a motion for appropriate relief. First, it has to be evidence that was not available at trial. That means that you couldn't have found it if you had investigated more. Second, the evidence has to be such that it would have changed the outcome of the trial. This has just been a brief overview. Of course, there are a lot of exceptions and different rules, and every case is different. You should definitely talk to an attorney no matter what if you think there's something wrong with your conviction and that you might have a basis for an appeal.